Any mention?
Lordship, I beg to mention item number 22, Lordship. 22. I'm for respondent to Lordship.
Why?
Lordship, the arguing counsel C. S. Walang is out of station, Your Lordship. We beg for 2 weeks' time, Lordship.
Second appeal.
Yes, Lordship.
No objection.
No objection, Your Lordship.
After 1 week.
2 weeks, Your Lordship. 2 weeks.
Yeah, they have no.
No objection. Similar with item 23, Your Lordship. 22, 23. Highly obliged, Lordship.
2 weeks.
My lord, I also want back to mention item 20 and 21, my lord. 20 and 21. I'm the petitioner, and MPSC is important. Mr. Paul is also not in the station, my lord. So on joint request, my lord, for a week, my lord.
On John Rickers, after 1 week.
Obliged.
Yes, Your Lordship. I should beg to mention item 26. Mr. Chanda is not available today, Lordship. Mr. Chanda is not available today. Item 26.
No objection. For dismissal from service.
No,
promotion.
this is regarding recruitment, Lordship.
2 weeks, yes.
Obliged.
Due to unavailability of Mr. M. Chanda. Yes.
Back to mention item number 18, Lordship. I'm praying for 1 week's time, Lordship.
What's 18?
This is that matter regarding WAF, Lordship.
Reconstitution of the work board.
And Mr. Paul's there.
Lordship, he's out of station, Lordship.
What remains as matter?
One petitioner has withdrawn. Now only one.
Exactly. The other one wants to continue.
Lordship.
Okay. After 1 week or 2
Lordship.
weeks?
1 week.
Okay, 2 weeks, yes.
2 weeks. Obliged.
I'd like to mention item number 19, Lordship.
Joint prayer.
We are making a joint prayer, Lordship.
This matter, my lord, after 2 weeks.
What's the matter about?
My lord, the same matter regarding that export of
Boulders,
stone, my lord, to Bangladesh.
Okay, 2 weeks, yes.
Obliged.
Obliged, Lordship.
Supplementary list, item number 1.
May it please your lordships. My lord, this is a case, my lord, where the writ petitioner, my lord, presently she is holding the post of Joint Chief Academic Officer in Ambush, Meghalaya Board of Joint Chief Academic Officer. My lord, this is a great
Chief Academic Council
officer.
Officer. Okay.
My lord, this is a senior grade 1 post. My lord, she is holding presently on a regular basis. Now she is entitled for promotion, my lord. The next hierarchy is the selection grade to the post of Chief Academic Officer. She is now eligible to be considered for promotion to that post. Now there is a single post, my lord, Chief Academic Officer. Now the respondent, what they did, my lord, instead of considering her case, my lord, they have brought somebody outside the cadre on deputations.
You mean as per this MBOC service
Yes, they have the service regulations.
She is supposed to.
Yes, she is eligible to be considered. Yes.
Okay.
Yes. Now, instead of this, they have brought somebody on deputation outside the cadre. They have referred to a rule that is wrong, number 1. Number 2, your lordship, the substantive post held by this person, well below salary-wise, well below the rank of mine. Now, virtually a person is, my lord, supervising me, who is substantially holding a post well below my rank. His pay level is level 19. My pay level is level 17. And my concern is, my lord, they are blocking my avenues for lordship. Ours is 19. Mine is 19, his is 17.
Is lower. How?
Sorry, 17, his is 17, my lord, mine is 19. Now, my lord, my grievance is now they are blocking my lord, avenues for promotion. They cannot have, should not have done it.
Where's the impugned order?
176.
Your Joint Chief Academic Officer.
Yes. Lordship will kind to come 176. In pursuance to provision below, Rule 6, Clause 1 of the Supplementary Service Regulation, Meghalaya Board of School Education 2019, and interest of public service, C. Junwart A. Marak, Associate Professor, District Institution of Education and Training, DIET, Resubelpara, is transferred on deputation and posted as Chief Academic Officer in the Meghalaya Board for School Education, Tura, in his own scale of pay with effect from such and such. No time is specified.
I heard Mr. SN.
I think my learned senior friend is appearing for Embos also.
No, Your Lordship, we have no instructions from members. I'm just appearing on behalf of the
Account
state,
body
1 to
has
7.
heard Mr. SN and counsel for the petitioner issue notice.
Were respondents this?
That EG with so first accepts notice on behalf of
1
respondent.
to 7, Your Lordship.
Number 127. Notice issued to respondents
8, 9,
within
and 10.
3 days. Yes.
I think my learned friend is also appearing for 11. 11 is also government, no? This Principal District Institute of
Diet.
Diet. This is government.
Okay, 1 to 7 and 11. Notice to issue response 8, 9, 10 and prior respondent 12 within 3 days. Is that after for instructions?
We'll send the notice by register post. Acknowledgement.
Daily list item number 1.
Yes.
Find the written submission.
Yes, for what?
Written submission.
Written submissions by parties has been filed. Same taken on board. Hearing concluded, judgment reserved.
Deep.
Item number 2.
Lordship, item number 2 and 3 are connected, Lordship.
Yes.
In the main writ petition, Lordship, we have taken steps on respondent number 6, Lordship. However, it
Number
is
2 and number?
3, Lordship, 3. The connected...
1 second. The contempt.
Lordship, however, in view of the interim order, Lordship was not inclined to...
Who's appearing for the respondent here? In a contempt. No, item number 2 who's appearing for respondent. Anyone?
Lordship, item number 2.
Who's appearing for respondent? Anyone's entered appearance?
Notice has not been issued, Lordship, considering that...
Okay, then let's take number 3 first.
Lordship.
Where's Mr. K.V. Bhattacharjee?
Lordship, yes, he's here, my lord.
Lordship, notice in respect of respondent number 6 is inconclusive, Lordship. I am praying for taking fresh steps, Lordship.
It's been?
Fresh steps, Lordship, in terms of respondent number 6, Lordship.
Why?
Lordship, we tried to obtain the status report, but it's inconclusive, Lordship.
Yes, with affidavit, Mr. Bhattacharjee.
Lord, I require a week's time, my lord.
Same deadlock, same deadlock.
No, my lord,
affidavit.
I have the instructions. I require a week's time.
Yes, Mr. K.V. Bhattacharjee, Naji and Bihar respondent 125, Mr. G. Dakhar. Council respondent with 7, pray for and allowed further 1 week's time while affidavit stop. Mr. S. Chanda, next paragraph. Please be allowed to take fresh steps from clause number 6. As status of service could not be obtained. Prayers are allowed just after 1 week.
Lordship, interim orders may continue, Lordship. I am praying.
Interim orders there?
Lordship.
Interim orders, any shall continue till the next day.
Lordship.
Item number 4.
Lordship, I may be allowed.
Rejoinder?
Lordship, no.
Why? We'll close it then.
Lordship, I need two more weeks.
How many times you prayed for
This is the second.
The second time she's asked.
Third time, Your Lordship.
Third time. Third and final policy granted to MSML Cloud. Then council press your file rejoinder. Stop.
Oblige, Your Honor.
Third and final policy of 1 week is allowed. 1 week you said, right?
2 weeks.
2 weeks to file rejoinder.
Item number 5.
My lord, in item number 5, my lord, on behalf of the state, my lord, the deputy commissioner affidavit is prepared and sent, my lord, but the only fact is that she is out of station, my lord. She will be here on Saturday, so I'll pray for a week's time, my lord.
This matter, in fact, this is with regard to electrocution of the student.
But we have taken all necessary measures after that. That unfortunate incident has already happened. That cannot be undone. But beyond that, now the only thing, though off the record I can submit, the ex gratia of 1 lakh rupees isn't paid to. That aspect, your Lordship may consider.
Your Lordship, I'll just seek
What instructions
instruction.
do you have?
Your Lordship, I've not received any instruction from my senior. I'll seek first
From senior or from your clients?
from my seniors, Your Lordship.
My lord, there was also a magisterial inquiry, my lord, which was conducted by
Where's the report?
My lord, the report we have it. So that is why we wanted to place it.
Six is whom? Who's number 6? What is he? Are you filing affidavit?
So this is what we wanted to include with the affidavit.
Do they have a copy of this?
Yes, Your Lordship.
The magistrate inquiry, you have a report.
Yes, Your Lordship.
Use a copy also.
This work's complete now. Re-electrification wiring. Now class is open.
In fact, in our affidavit, you said, my lord, that
2.5 lakhs has been paid. How much money has been paid?
Your Lordship, we've only received 1 lakh
1
of
lakh.
ex gratia.
Nothing in the report now, conclusion.
Only, my lord, it says that the death is due to
If you record many statements, at least you should generate. Who's this magistrate who did the report? Very perfunctory. Mr. Keyboard Chaji Leonard, GA for respondent 1 and 2. Praise for further time to file affidavit. Top legal counsel produced a copy of the magistrate inquiry and submits that the CM will be enclosed in the affidavit. Rinjal for whom? Who's respondent number 3? What do you have to say? Caesar report? An investigation? What's happened now? What do you mean matters been charge sheeted? Who's accused? Principal?
no, madam. The electrician. Electrician and one of the staffs, I think.
And the teachers.
One teacher. Hostel in charge teacher.
Then you already filed affidavit, right?
We have filed, madam.
Dr. N. Muzika, with MS so-and-so for respondents 4 and 5 submitted that since the incident and during the pendency of this matter, steps have been taken by the school authorities to upgrade all the electrical installations, and as on date the building is safe and classes are on in full swing. Yes. Stop. What's your name? Ms. A. Papang, what's number 6? That is number 6 is what? Is the Child Welfare Committee submits that no affidavit for county respondents. List after 2 weeks for affidavit by the respondents 1 and 2 for the orders. Can you come back whether you've got the further compensation or not? Because the recommendation is 2.5 lakhs. Who's to pay the compensation? The school?
School.
Item number 6.
Item 6A, Lordship, my lord, I've already filed the rejoinder affidavit through the online portal, my lord, and
We have not received.
Yes, who's appearing?
We have not received, my lord.
You give physical copy. What's your name?
Shivani Samarpita Ocha, my lord.
MS so and so submits that the rejoinder has already been filed online. However, Mr. N. Sankhan submits that please that
we have not received.
Physical copy may be served on them. Stop. The same as the praise allowed. List after 2 weeks for hearing. Correct? Yes,
Oh, please, my lord.
you serve a copy, physical copy.
Yes, my lord. Sorry.
May I please, Your Lordship? Here we're supposed to file the affidavit of service, Lordship.
Respondent's number?
Correspondent number 5, 6, 8 and 9, Lordship. Some more time to...
5, 6, 8 and 9.
Yes, Lordship.
Yeah.
On behalf of respondent number 7, my lord. 2 weeks time.
You haven't filed. You are for whom?
Private respondent.
You are with Mr. Day. Yes, MS also. Praise for further time. On behalf of the Council of Petitioner, praise for further time to obtain status and to file affidavit of service on the respondents. And to praise for further time to obtain status and to file affidavit indicating service on the respondents 5, 6, 8 and 9. Stop. You're Mr. DC Imli on behalf of respondents number 1 to 4 and MS Skeletap on behalf of respondent 7. Pray for now further 2 weeks time to file affidavit. All players allowed. List after 2 weeks before the order says.
Highly obliged, Lordship.
Item number 8.
Yes.
May it please your lordship. Lordship, we are still awaiting instructions, my lord, from Calcutta. We have received from our state.
Why
lordship,
Calcutta?
Because Meghalaya House is a party over here, lordship. Additional resident commissioner.
Okay. Yes. Your appearance matter with Mr. Gautam?
Yes, sir. Yes, sir, Lordship.
Yes, MS NG Shilla, CGA. If for further 2 weeks time to obtain instruction, expected that then on the next day the affidavit should be on board. Yes. Record. Thank you. Yes.
Apply, lordship.
Item number 9.
We've already filed our affidavit, Your Lordship, in this matter. We've already filed our affidavit.
You filing rejoinder or not?
No, Your Lordship. We need 2 week times.
No, you don't. You want to file or you don't want to file rejoinder?
We need to file a rejoinder, Your Lordship.
Yes, Mrs. Imli, please allowed 2 weeks time to file rejoinder after file fit respondents. Please allowed this after 2 weeks. Yes.
Obliged, Lordship.
Much obliged, Lordship.
Item number 10.
Yes.
The steps were taken, Millard, and my
I'm appearing, Millard.
friend is appearing.
What's the matter about?
Millard, for extension of time, Millard, under section 29 of the Arbitration of
Yes. Well, here what happened, Millard, I need to file a reply because what happened, Millard, the original claimant, Millard, he passed away during the pendency of the arbitration proceedings, Millard. Now his brother is trying to implead, Millard, now without any succession certificate.
But impleadment is already done.
They're part of the same firm.
Impleadment is already done, Millard.
Then?
Impleadment has not been done, Millard. That's my instruction. Because we have raised
Anyway,
objection.
you just take instruction, we'll have it after 1 week.
Millard, only one aspect, Millard, if I can bring it to your lordships. Millard, under the second proviso to clause 4 or subsection 4 Miller. It says that provided further that where an application under subsection 5 is pending, subsection 5 is this application for extension of time, the mandate of the arbitrator shall continue till the disposal of the said application. So, Miller, what appears to me is that because we have filed the application already, Miller, so
continue.
So it will continue. The arbitration proceeding is to continue, Miller. So if
I don't know. We'll have to examine.
Observation can be.
We'll have to examine the position first. Yes, you take 1 week. Dr. Mbosika,
10 days.
has an appearance today on behalf of the
Sole
respondent.
I think
Sole respondent. Such notice is complete. If priest was allowed 1 week's time to obtain instructions, then this extension, nothing is less after 1 week. But we'll get a date after 2 weeks only.
11.
Two to four is whom? Nehu?
Yes, Your Lordship.
Where's the affidavit?
Your Lordship, praying for 2 weeks' time to file the affidavit, Your Lordship.
Very difficult for affidavits to be filed in this court, it seems by counsel. MS Ibla, priest funds allowed further 1 week's time, enough.
2 weeks, Your Lordship.
What about number 1? MS Ibla, Vice, Ms. SN. First 1, 2, and 4 priest funds allowed further 2 weeks' time to file affidavit. This thereafter, and so on. Should require the contingent.
Item 12.
Respondent number 3 has been, we've taken steps on respondent 3 as well, my lord, on 28th of February.
Lordship, I've executed the wakalatnama on behalf of respondent number 3, but on going through the prayers, there might be some conflict with respondent number 2, Lordship. I might not be able to appear in the instant matter, Lordship.
At all?
Just 1 week's time, Lordship, for me to clarify the same. This is for reservation, Lordship.
Now that is 2 is state.
2 is the state, Lordship.
3 State Bank of India.
Lordship, because this is for to implement the reservation in the.
Then, like, how can you appear State Bank of India and for
Lordship.
state?
Exactly, Lordship.
Yes, it is submitted by MS Njishila that Njishila, learned senior government advocate, appearing for respondent number 2.
No, I'm not appearing for 2, Lordship. I'm not appearing for 2.
2, 3 won't appear.
Lordship.
You'll appear for 2 or 3. Make up your mind.
No, Lordship. Actually, I've been instructed by the bank to appear in this matter because I'm the standing counsel. But on reading the prayer, Lordship, there might be conflict with respondent number 2, which I'm senior government advocate.
So you won't appear at all in this matter.
Lordship, just give me 1 week's time, Lordship, because I've executed the wakalatnama.
That though she had executed a wakalat on behalf of respondent number 3, as there appears to be a conflict of interest with respondent number 2, she may be allowed to obtain instructions. What about number 1, Dr. Mazika? Yes, on behalf of respondent number 1, Dr. Mazika prays for a 2 weeks time to obtain instructions. This is a matter of 2 weeks for further orders. Yes.
Much obliged, Lordship.
13.
Lordship, we have taken steps upon the respondents.
Can you get translation? You want Okay.
Lordship, so far as respondent number 1, they have already received a notice. As per the reports.
Respondent number 1 is?
The police station, Lordship.
Yes, they also sent.
Lordship.
Where is this place?
This is in Rajasthan, Lordship.
Kota.
Kota. Lordship, so far as respondent 2 is concerned, it has returned back because he was not found. Yes, Lordship. Lordship, the reason is that he's not found in that address because he's in custody in connection with some other case. So, Lordship, I'll take fresh steps on that.
Where is he in custody?
Lordship, some jail in Kota, Lordship, in Rajasthan.
What's the matter about?
This is regarding the freezing of account, Lordship, SBI account. Lordship had passed an interim order whereby we were allowed to execute an indemnity bond.
So what remains here?
Lordship, the other aspect of the matter, Lordship.
Yes.
3. So far as 3 is concerned, Lordship, I'll take a status report from the post office.
A letter has been received from registry. Wherein communication dated 14 March 2025. No? Dated 14 March 2025 from the station house officer bracket SHO Ram Jamandi Police Station District Kota, indicating the fact that they have received notice and has been sent to the concerned respondent. Stop. Mr. M.L. Nongpina's paragraph submits that with regard to respondent number 2, he said respondent could not be served due to the fact that, as reported, he is in custody. Stop. What about number 3?
Number 3, there's no status report, Lordship. I'll take.
With regard to number 3, no service reports will be present. Accordingly, this is a matter after
2 weeks, Lordship.
2 weeks.
We'll take fresh steps upon respondent 2, Lordship.
2 weeks to allow the petition to take fresh steps on respondent number 2 and to obtain status of service respondent number 3. This on so and so.
Hello, Lordship.
Hearing 14.
They've come out with an application for substitution now, of Union Home Secretary and others. Well, I was just counting this the 5th Home Secretary during in the life of this contempt petition, my lord.
Let's close it.
And DG Assam Rifles, I can't even count, my lord.
Mr. Paul is not there. Item 16 was also there today. But then otherwise we are bound to implement because changes have come, my lord. Lordship may entertain it or...
Let's close this. Become a sad story, Mr. Pathak, this matter.
I understand, my lord. No, it has been made very sad by them, my lord.
It's completed 10 years, my lord, I think.
I understand, but then the way the facts and the matter was twisted by them, my lord. I'm giving up my prayer that the others have been granted a rank of warrant officer, that we are not pressing any longer. Okay, that may be a fresh cause of action altogether. But then the way it was implemented, my lord, when the SLP during the pendency of the writ appeal here was filed, because a writ appeal was preferred against the order of the single judge. Since there was no interim order, SLP was also filed. In the meantime, they said that we are going to comply, so the SLP was dismissed with the observation that you should not have filed when the writ appeal is still pending. Thereafter, my lord, on October 2015, they come up with a compliance that we are re-designated and upgraded to the post of Havaldar. Not warrant officer, I am giving up warrant officer. That was done. Then the writ appeal stood closed on 1st of March 2016. Then on 23rd of, after closure of the writ appeal, what they did is that they had undone the entire thing by saying that no, it was a promotion. In the month of September 2016, the second my lord order is passed. Now the first order that was passed, upgradation, was with instructions and with compliance and with, my lord, advice of the Ministry of Home Affairs. And the second order, my lord, is only a pure decision of the colonel of the particular Assam Rifles. He had not even consulted the Ministry of Home Affairs at that point of time. As revealed from subsequent correspondence, the ministry has been all along saying it's upgradation, but then it's Assam Rifle who has made it complicated, my lord, by saying.
Mr. Pathak, I'm saying if you, whatever it is, you don't want to go through the entire, the hassle or the harassment of, going by single bench, state appeal, and so on and so forth. But I think the way this matters running, you'll have no record, because for effective orders to be passed, you'll have to institute fresh proceedings, I think.
My lord, I understand that, my lord, because lordship cannot now set aside.
Now what your grievance is, what grievance are now you just look at from the from the aspect of contempt jurisdiction.
My lord.
Now contempt is very narrow. Now on who can you fix responsibility now? At this stage, we have come 10 years down the line. See, that is the thing.
5 home secretaries, my lord, and maybe 7, 8 directors and so something.
Yes.
5 home secretaries have come and gone, my lord.
What I had done, Mr. Paul had also on previous occasions emphasized that of late the Apex Court is also saying that contempt is not just punishment. When you see prima facie wrong implementation of the order has been made, the respondents can be asked to make or take corrective measures.
See, is there a case where there's blatant?
We are not asking for a fresh
the only
direction.
thing that they've twisted, the main thing is that they've twisted the implementation of the orders. Correct. That's all. And long series of litigation has been there, the n number of cases. And so, what do you seek to achieve now by continuing with this contempt? Do you think it'll undo everything? It will repair everything that's been done?
No, if only the first compliance of 23rd October 2015 is held to be the correct compliance in terms of approval of the Ministry of Home Affairs, ignoring the second subsequent order, my lord. At this stage, my lord, that would do.
We'll just give you a last opportunity. We'll implead, but then again you have to notice us to go. Otherwise, see, this court has been inclined to dispose the matter every time.
The difficulty, my lord, here is that none of these contenders, series of contenders have come. None of them has personally filed an affidavit till now. It's the law officer who has been filing all the affidavits. If the Home Secretary is asked, my lord, wants to clarify on this matter, I think he will immediately say that no, the order that was passed in 2015 with our compliance is the correct compliance.
My lord, your lordship will recall, this honorable court has passed several orders in respect of cipher category, my lord, saying that this upgradation is not a promotion, so cannot be. So that is a totally fresh cause of action, my lord, that requires substantive adjudication by this honorable court, which cannot be done in contempt proceedings, my lord.
That's what this court is expressing. If you want
Here they had already said it's upgradation.
Putting us to subsequently filing an affidavit from the Union Home Secretary, my lord. And as I submitted, 5 Union Home Secretaries have come and gone, my lord. So why don't they, my lord, this contempt may be closed by giving us that liberty, my lord, to file appropriate petitions if they want to.
Well, liberties will always be there.
You do that, liberty will be there, but Mr. Pathak, you get effective orders in the sense that what will be, that is the whole question is whether, the first order and the second order, the manner of implementation, that's all. How to twist it, from what it was and what it became.
No, that itself, the second order itself amounts to a contempt, my lord. It's playing with the court.
Right, but then the thing is that now...
What you could not achieve in the SLP, you are now trying to do it by executive order or...
As far as the next matter, my lord, which is Mr. Paul's matter, that concerns cipher category, my lord. Now, cipher category...
It's already been answered.
Answered in writ petitions, my lord, not in contempt, my lord. And these are connected matters for the last 10 years, my lord. In my humble sense, the matter may be closed, my lord, giving that liberty to approve...
They don't want... The thing is that why Mr. Pathak is maintaining this contempt, if I understand correctly. Firstly, the number of petitioners, correct? To gather people around again, to file a fresh writ petition, seeking the same relief that had already obtained in the first round. That's why the proceedings contempt.
But I'll point out in Mr. Paul's matter, the same the contempt petitioners, my lord, have come and filed a writ petition also and obtained relief also, my lord.
No, hard and fast rule, they can't come even to a contempt pending.
Well, that'll amount to parallel proceedings, my lord, again. And they got a relief, my lord, in writ petitions. So can they still be contempt petitioners, my lord?
Oh, Mr. Paul's clients are far better situated because they were given the rank of warrant officer. We were not given warrant officer, though we claimed. Therefore, as for us, my lord, to claim a benefit of warrant officer now is a fresh cause of action. But then what was to be done? The court said that you implement Fifth Pay Commission's recommendation. What the Fifth Pay Commission said is clear. Fifth Pay had redesignated certain posts that we are restructuring your cadre. Now the entire category of, say, for example, LDA has been called administrative assistant. This is only a redesignation of name with a corresponding change in pay scale. The entire category has moved from one step to the other, but then it's not a promotion.
No, that
is very clear, my lord. The lordship has held in a number of cases.
Well, the limitation for contempt is 1 year, my lord, under section 20 of the Contempt of Court Act, my lord. In one of the matters, Supreme Court said that if the cognizance is not taken within 1 year, my lord, in this present case, cognizance has not been taken till now, my lord.
No, I don't think so, my lord. We had approached within 1 year. Cognizance might take time. It might take time.
No, but some parity has to be drawn from there.
Either they close it or issue orders for, why they should not be punished for contempt.
I am taking a middle way, my lord.
Because the things that we're still in the first stage. Now the second order hasn't come. Because contempt matters, notice and opinion is one thing. But after the court is, satisfied that there is some substance in the allegation, then it issues a fresh notice. Then that's under the Contempt Code of Act. Then they answer. The show cause will not be punished.
I'm trying to take a middle way, my lord. Neither punish them, neither close my contempt. But then, since we find that prima facie there is an error in implementation.
What you want just some observations from this court,
my lord,
in this matter. We'll do one thing. We'll implead, but you take a call. Next date, we will not adjourn the matter any further.
Let Mr. Paul be also there, my lord.
We will not adjourn the
try.
matter any further.
Both
it's gone on long enough.
My lord.
It doesn't look good also to have a matter pending for over 10 years. Right, there's an application for substitution or for impleading the present Home Secretary, Shri Govind Mohan, Secretary to the Government of India, and Lieutenant General Vikas Lakhera, DGAR, as party response 9 and 10 in the contempt case number 23,015. Next part is submitted by Mr. B. Pathak that the impleadment is necessary as they are the present incumbents who are at the helm of affairs and who can ensure that the orders of the courts are faithfully implemented. Stop. Though the same objected to by Dr. N. Bozika, who submits that the contempt has since what?
It's pending for 10 years.
It's pending for 10 years and
it's outlived its life.
And has outlived its utility. The same should be closed. And if the writ petitioners are aggrieved, they are at liberty to institute fresh proceedings. Stop. Having heard the counsel for the parties, though keeping in mind the submissions of the learned DSGI, it is seen that though the contempt application is pending for a long time, the point in issue is short. Accordingly, the also the Article 10, Court Matters will stand impleaded as 1, 9 and 10, ready to make necessary corrections. We are accepting notice on their behalf. No further notice is necessary as Dr. N. Bozika will accept notice on behalf of 1, 9 and 10. Yes. Just after 2 weeks for further orders.
Well, I'll rely on the previous affidavit filed by Director General.
Yes. Can we have it on 8th of April, ma'am?
Not 8th of April? No, I think that's not a good date.
22nd, 23rd, because I'll be out for some time.
Yes. Have it 23rd?
23rd.
23rd, my lord, I will not be there. That night has to go in the month of May, my lord.
May.
Okay, this will be. But then be sure that we're not adjourning the matter.
Yeah, that is why, my lord, we are trying to have a consensus on the date.
Assist the court also.
My lord, definitely.
Okay. Yes.
16.
Who are you with? file it. Who's stopping you? Just together. Yes.
May I please, Your Lordship? Your Lordship, this is a part heard matter. And invite order 6/12/24, the respondent.
That's me, Your Lordship.
Where's the additional documents?
We have brought it today, Your Lordship.
You have?
We have brought it today, the original document, the original birth certificate.
What's the matter about?
This regards to family pension, Your Honor. Regards to family pension, the deceased employed left behind the petitioner, who is the second wife, and her son, and a minor daughter from the respondent number 4, Your Honor.
1 second. The deceased employee left behind the petitioner.
The petitioner and her son.
Yes.
And the daughter and a minor daughter from the respondent number 1 and her major son, Your Honor.
Respondent number 1?
Respondent number 4, Your Honor.
Respondent number 4 is Ruchika Lama.
Yes, Your Lordship.
Who is the parent of the state? Yes. You want this document to show that she's the daughter of the...
Yes, we have brought today, Your Lordship, the birth certificate. Here the question was on the last date, Your Lordship, why the son of my mother, respondent number 4, was not impleaded as a party, a son who is very much entitled for the pension benefit as well, Your Lordship. He was never made party here. So
actually, the son is a major, Your Lordship.
You are who's Sukulama?
my mother, Your Lordship.
Mother, okay.
Yes, Your Lordship. She's the first wife.
So she predeceased here the petitioner's husband, right?
It was
the first wife predeceased your husband,
yes,
correct?
Your Honor.
And 2 children.
2 children.
Yes. Now you got married to 2012.
Yes, Your Lordship.
And you have 1 son.
Yes, Your Lordship.
Okay. Okay. But the thing is that whatever it is he's nominated as, that's why the question is why he didn't implead them, because he's nominated by his late father as one of the nominees. Correct? Yes. What is this? See?
Here we have brought the birth certificate of the son, Your Lordship, Rachit Lama.
Is Ruchika Lama?
Ruchika Lama is the daughter, Your Lordship. She's a minor. And Rachit Lama, at the time of preferring the instant writ petition, he was 19
So your
years old.
mother's deceased. You share 50-50.
We are agreeable,
Here, Your Lordship, we are saying that the writ petitioner was never married to
Then
my
you
father.
go to file title suit then.
Yes, Your Lordship. Here, because why we are saying that, Your Lordship, because there are 2 death certificates brought by them. In fact, my death certificate as well, my mother's death certificate as well was fabricated by them, Your Lordship. That is the reason why here we are saying that
Nepal.
Yes, Your Lordship, they have brought it from Nepal.
Your Lordship, even the office acknowledged that I am his second wife, Your Lordship.
Yes. Where's the death certificate?
Death certificate of
Annexure 2, page 21, Your Lordship.
No, the death certificate with your mother. Where's it?
Death certificate of Suku Lama is also annexed by them, submitted by them, Your Honor, in annexure 6, Your Honor, of my affidavit. Annexure 6, page 23.
And in the
Annexure 5 as well, Your
applications
Lordship.
there.
Yes, Your Lordship.
Is it petition annexure?
In Madrid petition, also they have annexed, Your Lordship, the death certificate of late Suku Lama. They have not brought two death certificate, Your Lordship. But whereas in my affidavit, which I have replied, there we have annexed the death certificate fabricated by them, Your Lordship, by the petitioner.
Annexure 3.
Annexure 5 and 6 of my affidavit, Your Lordship. Your Honor, as per Annexure 5, the first death certificate submitted by the petitioner bears
So
the
he died
same.
on 20. What?
Died on 2062-9-10 BS, Your Lordship, as per the Nepal calendar.
And 2005?
That is the year 2005, the month of 11, November 25.
And then in this other one given annexure 4.
In the other death certificate, here also they have corrected that the late Suku Lama died on 25 December 2010.
Where is that?
Annexure 6, Your Lordship.
But this annexure 4 says that she died on 11/2/2011.
That is the actual death, Your Honor.
This is actually death certificate.
Yes, Your Lordship.
Then the next death certificate says she died in 2005.
Yes, Your Lordship.
Then the third one says she died in
2010.
2010.
Yes, that was brought by the petitioner from Nepal, Your Lordship.
Your Lordship, it was my deceased husband, Your Lordship, who has obtained all the death certificate. I have
Three
no
of them.
knowledge with it.
3 different dates.
No, Your Lordship, I am not aware
Then?
about the death certificate, as it was my deceased husband who has obtained the same.
That is wrong, Your Lordship, because as per
Now
the
the only thing, one thing, MS Karsi, that her deceased mother is the only one given as a nominee, correct?
Yes, Your
As a
Lordship.
nominee along with the children, correct?
Yes, Your
Now
Lordship.
only the children survive. One's a minor, one's a major. Okay.
Okay.
Now, according to you, since you were, where's the marriage certificate? Since he had married your second wife,
Yes,
and you have also an issue from the said union, then you're entitled to
50% share.
of the terminal benefits. Okay. Now, where's your marriage certificate?
It's in Annexure 1, Your Lordship, page 20 of my petition.
Oh, that's why this matter got stuck. You go to civil court then. This is also Nepal.
yes, Your Lordship. Here also there are two marriage certificates, Your Lordship.
What do you mean 2 marriage certificates? First wife died 3 times and you got married twice to him.
No, Your Lordship. I got married only once, Your
What
Lordship.
about documents is where the 2 marriage certificates? First one he got married on 3rd 12/2012. Then next one. How do you expect sitting in writ jurisdiction we can resolve this kind of issues?
Your Lordship, here as per the petitioner, they have said that they got married, the petitioner and my father, my late father, they were married on the year 2006 in the month of December 4th, Your Lordship.
Where does he get that from?
That is an Annexure 7 of my affidavit, Your Lordship. Annexure 7 of my affidavit, page 25.
This is absurd, really. Registered and so and so.
But Your Lordship, as per the marriage certificate which is with me, Your Lordship, I got married on 3rd 12/2012, Your
As
Lordship.
for the marriage certificate, where is that page?
Annexure 1, page 20, Your Lordship.
And this other one, see? Now this one says that you got married on
Here they have time and again they are correcting their own mistakes.
Where is this date given marriage in this marriage certificate?
It's here, Your Lordship. In my typed copy as well, it's there, Your Lordship. It's written BS. They have underlined that, Your Lordship. 3/12/2012.
No. Where's the English calendar one of this one?
English calendar they have not annexed, Your Lordship. Here only it's written in AD.
Okay.
Nepal calendar.
4/12/2006 BS calendars corresponds to which year in the English
This
calendar?
is 2006 English calendar, Your Lordship.
2006 only?
Yes, Your
No,
Lordship.
can it be?
Because as per theirs, I think so, 50 or 60 years ahead of our English calendar, Your Lordship.
It's 57 years ahead, Your Lordship.
57 years ahead? How are we going to go into all that? I think you have to file a suit because all are questionable documents.
Yes, Your Lordship.
Will you have witnesses to show that you were there in your marriage?
I pray for some more time, Your Lordship. I'll
What
seek
time? The
instruction.
thing is that this matter will not go anywhere.
One more.
The only thing is that they've asked you a succession certificate.
Yes, Your Lordship.
And with these documents, how do you expect to obtain the succession certificate? Now you've shown three dates where the respondent four's mothers died. 2 dates that you got married.
I have no knowledge about the death certificate, Your Lordship, since it was my deceased husband who has obtained
I
it.
think you'll have to go to civil court. We'll dispose her off.
I pray for some time, Your Lordship. 1 week's time.
Today, MS Archival produced the birth certificate of the other child of the deceased employee who is now stated to be major stop.
Your Lordship, here as per the Meghalaya Civil Service rules, Your Lordship, even the son is entitled to service benefit up to the age of 25, Your Lordship, as per the amendment.
Yes, anyway, we're not going there right now. A major stop. Upon hearing the counsel's questionable documents and disputed facts have arisen, especially as to the date of the demise of the mother respondent before, and also the factum of marriage and date of marriage of the deceased employee with the petitioner. Stop. MS Archival prays without further time to prepare the matter to seek further instructions. This after 1 week. This after 2 weeks. Otherwise, that's why I was wondering why this case is stuck. If it was a pension matter, usually you take this back. Anyway, it's okay.
17.
Hello, good day.
17.
Yes.
My lord, this is the land acquisition matter, my lord. Here I have found a judgment, my lord, on the same issue, my lord, where it says appeal is only appeal is maintainable, my lord.
Only?
Appeal, my lord.
What appeal?
My lord, here, my lord, they have taken the plea that revision is maintainable against the order passed by the special judicial officer. But here, my lord, if my lord will come to the last page, my lord, I've just marked it. It says, my lord, for the reasons indicated by us earlier, we are of the opinion that where there has been a valid reference to the court, whether under section 18, 30 or 31, any order passed by the court finally disposing of the matter so far as it was concerned would be appealable. So, my lord, the order which has been...
Not a 115, not a 227.
No, my lord, this is 54. This is, we have filed appeal, my lord.
Understood. Like this judgment deals me with the application of section 115.
They have filed revision, my lord.
Revision?
And in this case, my lord,
revision on 115 and 227 is like this, the difference between the sun and the moon.
Yes. Now, my lord, in this case, what has happened, my lord?
Only style is a revision
yes,
application.
they filed a revision petition challenging the rejections of their reference, my lord. And the court held that any order
passed in a reference under section 18, 30, whatever, is appealable order. Fine.
Yes, my lord.
But then revision in this case, what Mr. Gautam has argued last time, that It should have come to 227.
No, my lord.
That's an appeal.
It is an appealable order, my lord. This is very clear because it has finally disposed of the matter and it has confirmed the award passed by the collector, my lord. And on top of that, my lord, it has added the amount also, my lord, and given direction, my lord, to pay the extra amount.
So your stand is that any order passed by a court on a reference is appealable.
It is appealable, finally disposing of the
That's
matter.
correct also.
Yes.
But my stance is, my lord, any order passed is appealable under 54. But the only bracket there is whether, my lord, the court has considered the materials on record or not. And that can only be done by, my lord, leading evidence. In this case, that has not happened.
If that be the case,
my lord,
can file appeal, my lord.
But I can, in fact, I say I cannot file appeal. I'll also have to file a revision if I wanted to. I never did that. Now, my lord, what my learned friend has placed over here is, in that particular case, they file a revision. The court said no, any order at the end of the day, passing a judgment is appealable. But in that case also, the materials on record were placed before the court. The court ultimately came to a finding. Only two things can happen in a reference, my lord. Either you enhance or you upheld the award of the collector. But in this case, there is neither enhancement and neither the award has been upheld. The court has come to a finding that the entire thing was decided on the basis of an agreement.
But
so,
one thing,
accusation.
Mr. Gautam, you must remember that you have an appeal against the order. Is his appeal.
Yes. Absolutely, my lord. It is his appeal.
Then,
but then his appeal also has to be maintainable. And my lord, otherwise also, my lord, on merits also, my lord, there actually was a meeting between the parties, my lord, and that is a part of the appeal. My lord, it is already annexed in the appeal filed by my learned friend also. My lord, I'll just take you to that particular page. Page 53 of the appeal.
This is which year the judgment?
This is
1961.
Yeah, 1965, my lord, if I'm not wrong. Or 61 is.
Yes, okay, yes. What are you referring to?
I'm referring to page 53, my lord, of my friend's appeal.
53.
Yes, my lord. So, in case, my lord, we say that the appeal is maintainable, then too on merit, my lord, I do have a case to argue. Because I have not come to the merit of the case yet, my lord.
Yes, what's this meeting?
Well, look, this is a meeting, my lord, the minutes of a meeting between all the stakeholders. There they decided that, my lord, at the end of the day, my lord, the price of that property, my lord, at that point of time was above 700. And at the end of the day, my lord, I was paid a very lower amount. So even if my learned friend says that that judgment, my lord, is wrong, because the court has come to a finding that there was an agreement between the parties, and on the basis of the agreement, the award was passed. So, well, there seems to be something on record to show that there was the meeting of mind. All of them were present at the same place. So, my lord, there are other, well, because in fact, my lord, no paper book has been filed here. But I have got some documents, my lord. Allow me to place some documents before this court on the next date. I will, my lord, if lordship feels that an appeal is maintainable, then on merit, my lord, I'll try to make out a case. But at the end of the day, they are not disputing that there is an agreement between the parties.
No, without complicating the issue, we will hold that the appeal is maintainable. Because it's an order reference, rightly or wrongly, but maybe it is in divergence or deviant from an ordinary order under reference.
My lord.
Because it was only with the aspect of the component of the contingency costs.
My lord.
Yes, my lord.
Yes, which was directly given to you.
So if the
in this case, the finding is that it's based on agreement, so there was no contingency involved in coming to my lord. On a compensation.
So there's no question of deducting that. Because there's
no question of adding that in the first place.
No, my lord.
There's no question of adding 10%. There's no question of deducting.
My lord.
So if there's no question of deducting that, then it stands at zero. Then let the money go back.
Here, my lord, the entire award was prepared by the collector, my lord. The award itself, it shows very clearly, my lord. He has taken up the entire process.
What Mr. Gautam saying is,
yes, my lord.
If that's the situation, they don't forget everything. Whatever money is gone. Give the money to him. That's it.
No, my lord.
So anyway, forget about that. Yes. What do you want to show?
But Well, there are two aspects of the matter. First of all, I said that it's not
What
maintainable.
documents want to bring?
My lord, there are minutes of the meeting. People were present. An agreement is already there. They don't dispute that there is a tri-party agreement within the parties. What they say? No. You cannot dispute.
Was it entered in evidence?
My lord, the court.
Was it entered in evidence, those documents? Can the court say, unless it's entered in evidence now, can you produce it before the first appellate court?
In fact, my lord,
if you say it's just for
then
satisfaction
we
of the
say that,
court,
my lord,
that's a different thing, just to get the background. But if you say that it's going to take into consideration, we cannot.
Cannot, my lord.
So that is why, my lord, I say that materials were not taken into consideration, my lord. I have placed a judgment before this court.
Please say this.
Just give me 1 week's time, my lord, because what I feel is, my lord, at the end of the day, if the court had come to that particular finding, is because there was an agreement between the parties. They were meeting. Minutes of the meeting are very much there. They decided on a particular amount. Of course, at the end of the day, they paid less. So the question of interpolation will not come because, my lord, at that point of time when the agreement was decided, they were not sure about how much amount is to be paid. That amount came to be decided when there was a meeting between the parties, and we have minutes of the meeting. I'll just place that, my lord. One last chance for me to.
One last chance.
Just give me 2 weeks time. This case is very interesting otherwise.
Very interesting. But anyway, the tentative view is that it will have to be an appeal only.
Yes.
Yes. Mr. Kisi H. Gautam, after some basically term praise, he will allowed to place some documents on which he seeks to rely upon. Yes, praise allowed. This after
2 weeks.
Obliged.
And I thought that matter can be finished out today.
But after next date, my lord. Obliged.
Obliged.
Item 24.
Ready the matter today?
Yes, Your Lordship.
We'll pass orders then.
Your Lordship, I have already submitted 3 judgments, Your Lordship.
3 documents, judgments.
3 judgments, Your Lordship.
Yes, Dr. Mozika, she has so 50%. How old is the lady?
69, Your Lordship.
Is there any chance for any kind of a middle road?
Well, our case is, my lord, under CRPC, the trial court may not have that power, my lord. But this honorable court can exercise 226, my lord.
226?
482, my lord.
It's not a 482.
This is 226, 227.
It's a civil writ, Your Lordship.
Which judgment you placed?
Your Lordship, I have placed 3 judgments. It must be in the file. One is State of Karnataka versus SB Shiv Shankar, Your Lordship.
What does it say here? What does it say?
Your Lordship, this is also this is quite similar to our case, Your Lordship. Here also, this was a case under Section 27 of the Drugs and Cosmetics Acts, wherein the accused pleaded no, Your Lordship, filed a plea bargaining application, Your Lordship. After hearing the parties, it was given below the minimum punishment till rising of the court and 10,000 fine, similar to our case, Your Lordship. Here also they filed, they preferred appeal, Your Lordship, which was dismissed, Your Lordship.
What does it say?
Your Lordship.
Finding, what page? Well, this is under plea bargaining, correct?
Well,
Your Lordship, if I may take you to page 21 of the said judgment.
Yes.
Para 20, Your Lordship.
Yes.
Keeping in view the above rulings, it is opined that the present petition, which is preferred by the state, challenging the impugned judgment rendered by the first appellate court in criminal appeal so-and-so, ought to be dismissed. In CC number so-and-so, before the trial court, an application was made by the respondent/accused under section 265B of CRPC seeking plea bargaining on so-and-so date. It was only on mutually extending the benefit of plea bargaining in between the complainant and the accused, but the complainant is the gravamen of the incident narrated in the complaint either orally or in writing. But in the instant case, criminal prosecution has been initiated keeping in view under section 200 CRPC and so also section 190 of CRPC relating to cognizance in respect of criminal prosecution initiated against the accused relating to offence under section 27D of Drugs and Cosmetics Act. When the parties had mutually come forward seeking plea bargaining in order to close the criminal prosecution case in terms of the issues emerged in between them for violation of the provisions of Drugs and Cosmetics Act, the trial court had accepted the application filed by the respondent/accused and extended the plea bargaining benefit, which has also approved by the complainant/state, who was represented by Assistant Public Prosecutor, in view of the fact that the accused had pleaded guilty and agreed to pay a fine of 10,000 and to undergo imprisonment for 1 day till the rising of the court. Therefore, in this petition, it does not arise to call for interference the said judgments of the trial court as well as the first appellate court, since there are no warranting circumstances which arise to call for interference. In view of that, I proceed to pass the following. This judgment is very much, it's quite similar to our case also, Your Lordship. Here also, in our case also, plea bargaining was filed. After hearing both the parties, Your Lordship, if I may take you to page 83 of the writ petition.
'83.
83, yeah, the last page, Your Lordship. This was the report, Your Lordship.
Yes.
The accused Prakash Kaur is presented along with her counsel so-and-so. Learned PP for CBI so-and-so is present. The accused had filed an application under section 265B CRPC for plea bargaining. The accused had been charged with an offence under section 13.2, read with 13.1 of the PC Act, read with section 419/420 IPC. In working out a manually satisfactory deposition, the accused was explained about the punishment that has been prescribed for the offence committed by her. The prosecution submits that the instant case relates to cheating the government and obtaining undue pecuniary benefits, and the court may proceed in accordance with section 265E, and she may be awarded the minimum punishment prescribed for the offence. The accused during the meeting has admitted that she has committed the offence and is ready to face the consequences thereof, and agreed that she may be awarded punishment as prescribed. This court has suggested that considering the age of the accused and her health conditions, she may be sentenced to pay a fine of 50,000 and to undergo simple imprisonment in lieu of the minimum punishment for the offence. Next line is important, Lordship. The parties have agreed to the suggestion of the court.
So the PP of CBI was there also?
Yes, Your Lordship. Can you, Lordship, kindly come below? The prosecution is there. He has signed Ronak Kumar. He has signed, and even the counsel for the accused, both has signed, Your Lordship, and it is agreed by them. Till now, there's no report from.
You paid 50,000.
Yes, Your Lordship. That day itself I paid, and the whole day I was in the court, Your Lordship.
Where does it say? Just undergo in prison for 1 day. It doesn't say.
Your Lordship, that will be in the judgment, Your Lordship.
Is the report? Where's the judgment?
Judgment will be page 12, Your Lordship.
Yes.
CR put up before me, accused so-and-so is present along with her counsel so-and-so. Shri so-and-so PP appears for CBI. Judgment is ready and pronounced. The accused had deposited the fine of rupees 50,000. The accused is released after undergoing simple imprisonment till the rising of the
Have
court.
you filed affidavit here indicating her age and her health condition?
Your Lordship, I filed the counter, Your Lordship.
So, indicating her age and health
Your
condition?
Lordship, there one slight mistake. It's on my part. Age I have written 66. It is 69, Your Lordship. It was my mistake.
What about health condition?
Health conditions.
Do you annex medical certificates?
No, Your
showing
Lordship.
that she's in infirm health. If she's fit to serve sentence, then the court is bound by 50% of the minimum sentence, right? That is how many years?
Minimum 1 year.
When 6 months.
Well, I'll distinguish this judgment. This judgment of Karnataka, my lord. My lord, kindly come to para 4, my lord.
Or a judgment? 1 second. So if she's 69 now,
Yes.
she can come out when she's 70.
Sorry, Your Lordship.
She can come out to 70 after
70
she
she's turning on May, Your Lordship.
By now, she would have already served more.
It's to May she's turning 70, Your Lordship.
She already served if she... Anyway, yes.
Para 4, my lord, of the judgment, of Karnataka judgment. It's quite distinguishable.
No, but Dr. Brazia, I found a way out because she's 70 years old. If she's already gone for plea bargaining, why just put her to further misery? Which one? Air no, which one is that?
This is Karnataka judgment, State of Karnataka versus so-and-so.
Yes.
Para 4, my lord. But somewhere Seventh line, my lord. According to the provisions of section 27D of the custom.
Yes.
If a person contravenes the said provision, he or she shall be punishable with imprisonment or for a term which shall not be less than 1 year, but which may extend to 2 years, and with fine, and which shall not be less than 20,000, provided, this is important, my lord, that the court may record adequate or special reasons in the judgment in order to impose a sentence of imprisonment for a term less than 1 year. So in these circumstances, there was a power under the Act, my lord, to punish below 1 year also.
Let's see, I'm not seeing the Drug and Conspiracy Act. You have it with you.
PC Act says 1 year minimum, no further. Drug and cosmetics.
So we can't go in statute, you mean?
But this will not help.
No, we go beyond statute then,
well,
by voting the relief. Yes.
Your Lordship, also in
And you should have put some, at least some medical certificates to justify the decision of the court. Court's trying to help you. Otherwise, you have to serve minimum of 1 year.
Your Lordship, the other two judgments also is there, Your Lordship.
I'm not at your case, you're not looking at judgments. I think that you should put some material showing that she's got this condition, that condition.
Your Lordship, she is having, she's now old, Your Lordship.
You file an affidavit, bring the condition,
Yes,
then
Your
we'll
Lordship.
pass orders.
Your Lordship, then I'm praying.
How will we justify it?
Your Lordship, then I'm praying for 2 weeks time.
Life begins at 70. You don't know that.
Your Lordship, I'm praying for 2 weeks time to bring on records, Your Lordship.
Yes, MS P3 and the course of hearing please
some
allow
reason on
some
227
time to present to file medical certificates showing the health condition of the petition of the respondent stated to be 69 years old presently. Yes, sir. I'll pray 2 weeks time. We're trying to help you. That's all.
Yes, Your Lordship.
1 year.
There's some reason on 226 power also, my lord.
Yes, get some reason to power also.
Yes, Your Lordship.
Because we are not going as per statute, we are going as per not under the PC Act, going under the
25.
the court. Otherwise, if you don't bring, then she'll have to go to next birthday. Will be in jail.
Your Lordship, I'll bring Your Lordship. Deeply obliged, Your Lordship.
Yes.
May it please your lordship. My lord, this is the same teacher's matter where she has been denied of her salary, my lord, since the time she has joined the service, my lord. My lord is very needless to say, my lord, the right to livelihood, my lord, cannot be subjected to the individual fancies of an authority, my lord. Here, there was an interview. They have appointed me. My appointment was forwarded to the government as required under the law. The approval was given by the government, my lord. Approval was given by the government. I joined the service, my lord. After subsequently working for some time, some individual person, my lord, who did not qualify in the exam, my lord, in the interview, filed a writ before this honorable court, my lord. There was no stay. I continued to be allowed to work, and till today I am teaching the students, my lord. Till today I am teaching the students, my lord. And in fact, my lord, on the Teachers' Day, my lord has passed one order where my lord has said that if the salary is admissible, please pay her. And pursuant to that order also, my lord, I have requested the managing committee, please release the salary. Now the government is saying that the financial proposal, the budget proposal is not been forwarded by the managing committee. Therefore, I am helpless. I cannot pay you the salary. So now the managing committee is silent, my lord. Completely silent, my lord. So therefore, my lord, this is amounting to infringement of my right to livelihood, my lord, and also the right to my right under Article 300A, the right to the property, my lord, because this has accrued as a property.
What right to property? Salary is property now.
300A, my lord, it's that.
There is no one shall be deprived of property except by due process of law.
Due process of law, my lord. Now, what is the due process of law here, my lord? Nothing, my lord.
You're stretching 300A. You just is a school teacher's case.
My lord.
Anyway, yes.
Lordship, it's not that the petitioner has been deprived of her salary, Lordship. As a matter of fact, Lordship, the managing committee has not submitted the salary
requirement
proposal to the DSU for necessary sanction.
Yeah.
We have instructed the managing committee to take
What's the
action, but
managing committee?
Lordship.
What's the problem?
Lordship, what has happened, Lordship, is that Lordship is already aware that the petitioner's appointment is under challenge in Lordship in petition 425, Lordship, on many grounds, Lordship.
The thing is that if she's still validly working, then she's entitled to.
She is working, Lordship.
Then,
Lordship,
then pay her.
concede that, Lordship. Sorry, I have instructions to submit, Lordship, that the school is willing to, Lordship, pay a fixed amount, Lordship, till the till the disposal of the final writ petition,
Look at the
Lordship.
Annexure 3. This is August 1. She was approved.
Yes.
It's 26 August 2022.
Lordship, what had happened, Lordship, was she had joined prior to the approval by the state government, Lordship. So that is also one of the grounds on which her appointment has been challenged, Lordship. And she is a commerce graduate and she has been appointed for arts vacancy, Lordship. That is also one of the grounds, Lordship. And the school managing committee submits, Lordship, that till the disposal of the writ petition, Lordship, the school is ready to pay a fixed amount from the school fund, Lordship.
See, it was order 5-9, which is Annexure 5. Since that time, since then, you've not been paid?
No, my lord, it's not paid. I have also requested them again and again, my lord.
Never been paid?
No, my lord, they have never been
That's
paid.
from the date of appointment.
From the date of my appointment, they have never paid me, my lord.
From the approval?
I'm sorry, my lord.
Date of the approval since
Yes,
22.
yes, my lord. Since August, that's why my prayer is there, my lord. Salary, my prayer is since August 2022, my lord.
4 to 5 disposed of?
I'm sorry?
WC 4 to 5 is pending?
No, it is pending.
Where is it pending?
Before this honorable court only, my lord.
Before this honorable court, Lordship.
But there's no stay. There is no stay, my lord.
4 to 5. Why is it listed together?
I'm sorry, my lord.
Why is it listed together if it involves the same school?
Lordship, on the last occasion, Lordship had ordered that these matters may be tagged together, Lordship.
Someone?
Sofikul
Islam.
Sofikul Rahman.
List this matter together to 4 to 5 in day after tomorrow.
Day after tomorrow, my lord. Well.
How's obliged, Lordship?
Obliged.
Oh, bakli biasa po you.
4 to 5.
4 to 5. 4 to 5.
They want to check the orders first because they had gone to the other court.
Okay, my lord.
Due to roster.
Yes. So, but this matter
This
can
is
be.
the matter they have tomorrow able to registry to. No, this is a matter they have tomorrow together with 4 to 5.
Yes, madam.
You have the problems you noted in the office note.
Obliged.
27.
Yes, what's this?
My lord, Dr. Moziga just had to leave to the division bench. This was a very short matter, otherwise, my lord, I had a word with him. This was a case of compassionate posting, my lord. The last leg posting. Last posting. So the petitioner, he gave a representation, my lord, giving a choice of 3 posts initially. My lord, this was in 9th April 2024.
In?
9th April 2024.
9/4/2024.
Annexure 2. But my lord, before consideration of my representation, these posts were filled up by some other persons, as in Annexure 3 and 4.
This issue to applicant posting, last leg posting, respect of so-and-so versus Devan Patti. Now, where we asked for?
Then, my lord, they filled this post
Now
up with somebody else.
Happy Valley, Dimapur, Jaluki, and
My lord, as of now, my lord, Annexure 6, I had submitted a second representation as per their request. They said that we have already filled up the post that you have given a choice for in April. So, in the month of, my lord, July 2024, as per their request, I give a second representation, my lord. My lord, that again is turned down at page 27, my lord.
So, given Guwahati, Delhi, Kolkata, and Dimapur.
My lord. Page 27, my lord. Again, they turn out that there is no vacancy, my lord, again. So, at best, at this stage, I can ask that I may be permitted to give a third representation, my lord. Every time they are saying that.
Why presently no vacancy is the choice opted by the officer for so and so. Hence, common request for last leg posting has been rejected. When are you retiring?
My lord, May 2026. Last only 1 year left, my lord.
Yes. Yes, Ms. Chan.
Your Lordship, I pray that this matter may come up tomorrow, Your Lordship.
Tomorrow, Mr. Pathak will be far away tomorrow.
My lord, that was my only submission. I can be on VC tomorrow then, my lord.
Tomorrow
My
we'll
lord.
dispose it of.
My lord.
One matter. Yes. Hello? Yes, this is matter tomorrow. Yes, as a fixed matter.
Obliged.
Deeply obliged, my lord.
What happens in such cases? If your last leg requests, you ask make request and there's no, then what happens?
My lord, they can reconsider, but
They
then
can
ultimately it's
can
the
they-
employer's
can they-
discretion.
Can they offer you some places?
They can
Instead
also,
of
my
you
lord.
representing for,
They can also, it's
maybe
up to them.
because we work out at Y Media, instead of
My lord.
you opting, let them offer you some places.
My lord. Because it's ultimately the employer's discretion. I can only ask, my lord.
Yes.
But then wherever I am posted, I have
Exactly.
to.
So let them give you where it's most suitable for you. From the places that they give, then you can.
My lord.
Yes.
Deeply obliged, my lord.